Hello, everyone, and welcome to our Title IX trainings. My name is Dean Shatley from the law firm of Campbell, Shatley in Asheville, North Carolina. And today we are going to be focusing on the legal obligations and roles under the new Title IX rules and regulations promulgated by the Department of Education. With me, I have my colleagues, Ashley Leonard, as well as Christopher Cottle. And this is going to be Section 1, the Title IX Fundamentals. Section 2 and 3 will be also covered in the second video in this series. Sections 4 and 5 will be covered in the third video, and Section 6 and Section 7 will be covered in a fourth video. So for now, I'm going to go ahead and turn it over to Ashley and let her begin.
Thanks, Dean. So this slide is just a 30,000-foot overview of the sexual harassment misconduct reporting process that we'll be taking you through in detail in each training video. But this just gives you an idea of what the process should look like. Most community colleges should have received this in addition to our advisor when the new Title IX final rule came out. But we will be including this slide with the presentation as well. So first, basic overview of Title IX. Title IX is part of the Education Amendments of 1972, which is a civil rights law that prohibits discrimination on the basis of sex in federally funded education programs and activities. All public, private, elementary and secondary schools, colleges and universities receiving any federal financial assistance must comply with Title IX. The Department of Education's Office for Civil Rights is responsible for monitoring compliance with Title IX, in addition to state and federal courts that decide litigation. So what is sex-based discrimination? In Title IX, in the Education Amendments, surprisingly, it's not defined. The Department of Education follows the Supreme Court's approach in interpreting conduct on the basis of sex to include conduct of a sexual nature or conduct referencing or aimed at a particular sex. OCR, the Office for Civil Rights within the Department of Education, periodically explains its interpretation of Title IX by issuing guidance documents, usually titled Question and Answers or Dear Colleague letters. This is a history of recent guidance from early 2000s to mid 2000s. You had revised sexual harassment guidance that described harassment of students by school employees, other students, or third parties that were prohibited under the OCR's guidance. In 2003, OCR issued a Dear Colleague letter regarding the First Amendment in Title IX. In 2006, they issued a Dear Colleague letter regarding various issues involving sexual harassment. In 2011, they issued a Dear Colleague letter regarding sexual violence. And in 2014, they followed that up with the Q&A regarding sexual violence within Title IX. So then in 2016, after the presidential election and a change in administration, they issued a Q&A on campus sexual misconduct in September 2017. And along with that, a Dear Colleague letter that rescinded the April 2011 and April 2014 Dear Colleague letter and Q&A on sexual violence. They said in 2017 that new regulations would be forthcoming, and they issued those new regulations in 2020 in May, and they issued a separate Q&A this September regarding the regulations that they issued in May. And all of our content in these training videos are based on the regulations issued in May 2020 and the Q&A issued in September 2020. So the final rule that we're going to be talking a lot about, Secretary DeVos, the Secretary of Education, announced the intention to restructure Title IX, which had not been done since its enactment in the 1970s. There was a public comment period from November 29th, 2018 through January 30th, 2019. The Department of Education received over 100,000 public comments on the Title IX regulations, and so it took them a very long time to go through all of those because they are mandated to go through each one and respond. They ended that process in May of this year when the final Title IX rules were announced, and the final Title IX rules became effective August 14th, 2020. And just a note on the difference between what was issued May of this year versus what's been issued in the past. The regulations issued in May have the force and effect of law. Everything prior to that was considered guidance, and most colleges and universities followed that guidance, or to the best of their ability tried to follow that guidance. But what's been issued this year is different in that colleges and universities must follow. So what is covered based on what has been issued this year in the Title IX final rule? Allegations of sexual harassment that occur in an education program or activity located within the United States and of which a recipient of federal funds has actual knowledge. If a person within your college alleges misconduct that fits in the above description, and we'll go over the definitions in just a second, institutions have a duty to respond under Title IX.
So Ashley, I have a question. It seems like part of the new rule or the new regulations from the Department of Education only discuss sexual harassment. So what happens if you have an allegation of sex discrimination that doesn't rise to the level of harassment as defined in the new rules? And let me give you an example. For instance, a student complains that a work-study program at the college is discriminating against female students in the hiring process. How would that be handled?
So in that instance, and what you'll see in just a second, is that the definition of sexual harassment is very narrow in the new Title IX regulations. So in Dean's example of a work-study program where female students are saying that they're being discriminated against, that most likely will not fit the new definition of sexual harassment. But your other policies within the college would cover that. So your discrimination and harassment for other sex-based discrimination could cover that, or your student code of conduct could cover that. If something doesn't fall within your new Title IX policy, it most likely falls under a different college policy. So the three key definitions that everyone should know is actual knowledge, sexual harassment, and education program or activity. Actual knowledge means that the college has notice of allegations of sexual harassment by the Title IX coordinator or any college official who has authority to institute corrective measures on behalf of the college. And we'll get into each of these definitions in more detail in the next couple of slides. But just as an overview, sexual harassment is three things under the new Title IX regulations. It can include quid pro quo harassment. It can include unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the college's education program or activity, including conduct based on sex stereotyping. Sexual harassment can also include any instance of sexual assault, dating violence, domestic violence, or stalking. And then education program or activity means any locations, events, or circumstances over which the college exercised substantial control over a respondent and the context in which the alleged sexual harassment occurs, including any building owned or controlled by a recognized student organization. So going back to the sexual harassment definition, Remember, it's those three different types of sexual harassment. Quid pro quo harassment, which is conditioning the provision of an aid, benefit, or service of the school on a person's participation in unwelcome sexual conduct. An example of this would be conditioning a student getting a higher grade in a class based on their participation in unwelcome sexual conduct. Or on the employee side, conditioning a bonus or a promotion on their participation in unwelcome sexual conduct. The second example of sexual harassment is unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. And there are multiple elements within this type of sexual harassment. So it needs to be severe, pervasive, and objectively offensive. So there's an objective component and a subjective component. It must effectively deny a person equal access to a school's education program or activity. The third type of sexual harassment is sexual assault as defined in the Clery Act, or dating violence, domestic violence, or stalking as defined in the Violence Against Women's Act.
Ashley, let me ask you a question here, particularly about sexual assault or dating violence. As you went through the previous definition of education program or activity, if a student alleges some sort of sexual assault or dating violence that does not take place on campus or in any particular education program or activity, it would not fall under the new Title IX regulations and the college's Title IX policy. Is that accurate?
That's accurate, yes.
But in those circumstances, would the college still have the ability to review this conduct to see if it creates some sort of disruption on the college campus and to take action if they felt that it did, if there was a nexus to the college campus and its environment?
Yes. So a person could allege that they were sexually assaulted off campus, but also that sexual harassment is occurring on campus as a result of that, because maybe the two students are in the same class and the person doesn't feel like they can come to class. In that instance, you may proceed under your new Title IX policy for the sexual harassment, the alleged sexual harassment that's occurring on campus. Or you could follow a separate college policy, again, your student code of conduct or an employee code of conduct regarding an employee or a student's conduct off campus that results in harm on campus. Does quid pro quo harassment need to be severe, pervasive, and objectively offensive? Or what about stalking, sexual assault, dating violence, or domestic violence? The answer is no. It's only this second type of sexual harassment that needs to be severe, pervasive, and objectively offensive, that it effectively denies a person's access to an education program or activity. So to go a little bit more in depth on actual knowledge, I am going to ask Chris to talk about this.
Hey, everybody. One of the things that Ashley mentioned in the definitions, and one of the things that the Title IX coordinator and other Title IX personnel that we'll talk more about today, one of the initial things you have to determine under the policy is whether or not the report that has been received is actually sexual harassment, and if it is something that the college has to address under its grievance policy. So one of the fundamental aspects of that is determining whether or not the college has actual knowledge. So actual knowledge, we talked about the definition. Let's look at more of a discrete example to see whether or not this employee has actual knowledge. So the hypothetical in front of you asks, after class, an adjunct accounting professor is approached by one of his students. The student asks if she could transfer to another section in the course. The professor then asks why, And the student answers that another student in the class had made several comments about her body during class lectures, and she's now saying that she cannot concentrate in class. Additionally, the student asked the adjunct professor to keep their conversation confidential because the other student in the class is in a romantic relationship with her coworker at the on-campus library. So this is a fairly typical fact pattern which could occur on the college. So the question is, does this report to the adjunct professor trigger the college's response under Title IX? So the first thing you should determine is whether or not this report imputes actual knowledge to the college. So if you remember, one of the things that Ashley discussed is that in order for there to be actual knowledge, the Title IX coordinator, the actual person who is designated as the Title IX coordinator, they have to be the one that received that report, or a college official who has the ability to implement corrective measures under the Title IX policy. So the first question is, does this accounting professor meet either one of those two categories? And the answer is no, under the new Title IX policy. The adjunct professor is not the Title IX coordinator, and they are not a college official who has the ability to implement corrective action. Now, who are college officials who might have the ability to implement corrective actions? That is going to vary somewhat from college to college, but typically outside of the Title IX coordinator, you are looking at people at the very highest parts of the organization, particularly the president, some of your vice presidents, perhaps your dean of students or your student services coordinator. Those are people that may have an ability to implement corrective measures. But one of the key distinctions in the new Title IX rule is that it does not extend to all employees. Knowledge does not extend to all employees on the campus, particularly your professors who may be interacting with students and also may be fielding some of these reports. So the next sort of thing that you'd want to think about is, if this was a professor, is what is this professor supposed to do with the knowledge that they have been given by the student? So in the facts, you can see the student ask, kind of details what's going on in the class, is looking to go to another section, but she asked the teacher to keep it confidential. So does the teacher have to keep this confidential? Ultimately, under the new Title IX rule, it is really in the discretion of the professor as to what they want to do with this report. And it's going to, and that is a decision that the professor has to make. Now, if the professor decides to share this information with the Title IX coordinator or another college official that has the ability to implement corrective measures, that communication would then trigger the college's policy, and the report would have to be investigated and the grievance policy would have to be followed. But there's nothing in the new Title IX rule that requires this professor to make that report to the Title IX coordinator. They may, and then oftentimes they are encouraged to, but they are not required to give this report to the Title IX coordinator or anyone else in the organization. Things that so what could the professor do? The professor, among other things, could certainly let the student know about the existence of a Title IX policy, where to find it online. Certainly could easily direct them to the Title IX coordinator, give the student the option to consider making a report directly to the Title IX coordinator. At some of your colleges, you may also have the opportunity to have on-campus or external relationships with therapists or counseling, where the student might be able to get counseling if this is having a deep effect for them, or if that's what they choose. And those would be perhaps confidential resources. So ultimately, the take home here is that under the new Title IX rule, only a certain couple of individuals in the Title IX personnel, their knowledge is the knowledge that triggers liability under the Title IX policy, not every employee on the campus. But again, in each instance, there will be facts that will make this sometimes a difficult analysis. So always look at each case on a case-by-case basis.
Thanks, Chris. So we've talked a little bit about sexual harassment and the 3 different types of sexual harassment that fall under the new Title IX regulations. And we've gone into more detail into what actual knowledge means. But what about education, program, or activity? So education, program, or activity includes all of the operations of a college or other post-secondary institution. It also includes locations, events, or circumstances over which a recipient of federal funds exercises substantial control over both the respondent and the context in which the harassment occurs, including any building owned or controlled by a student organization that is officially recognized by a college or university. So I'll ask Chris, which circumstance, if any, does not constitute an education program or activity? A student alleges she was sexually harassed by another student during a culinary class. B, a student alleges his professor sexually harassed him during an off-campus clinical rotation. Or C, a student alleges she was sexually assaulted at an off-campus apartment by another student.
So I think looking at the answers, the first question talks about the student's allegation of sexual harassment against another student in their culinary class. So culinary class would be part of an education program or activity. So if the Title IX coordinator or a college official with the ability to implement corrective measures was given notice of that report, then that would trigger the Title IX policy. The second one is a little different because the student's alleging that a professor has harassed him at an off-campus, but it is off-campus, but it's within the context of a clinical rotation. So clinical rotation is the key there because that is still part of the school or the college's education program or activity. The on-campus, off-campus distinction is helpful, but it is not determinative when you're trying to analyze the scope of the education program or activity. It's always a factor, and sometimes it'll be a very easy analysis, but oftentimes it will make things a little more difficult. So I think the right answer is C, which is where the student has alleged sexual assault at an off-campus apartment by another student. Again, it's off-campus conduct, but that's not entirely determinative. If you look back at the definition of education program or activity, at some of your colleges, it's possible that this sort of harassment could be happening in buildings that are also owned, even though they're off the main campus. They may be owned by the college, or they may exercise some sort of substantial control over that building where the harassment or the incident is alleged to have occurred. So always, look at the off-campus, on-campus distinction, but you have to think very broadly and look at the facts of each case to decide whether or not it falls in that definition and the scope of the education program or activity. So I would say it's C.
You'd be right.
That's good.
A separate part of the new Title IX regulations is a prohibition on retaliation. So the Title IX regulations state very clearly that individuals, departments, and colleges may not intimidate, threaten, coerce, or discriminate against an individual for the purpose of interfering with their Title IX rights, or because they filed a complaint, testified, participated, or refused to participate in a Title IX proceeding. And that may be a difference from what you've done in the past, where you might have mandated employees' participation, but under the new Title IX regulations, everyone has a choice whether they want to participate in a Title IX grievance proceeding. Also, the Title IX regulations make clear that the exercise of First Amendment rights does not constitute retaliation.
Ashley, I want to talk a little bit about the last bullet on this slide and the First Amendment provision. A lot of laws have anti-retaliation provisions. And Title IX is not necessarily unique in that regard. But based on all the Title IX guidance that we've seen over the last 10 to 20 years, isn't this the first time there's been a provision indicating that someone exercising their First Amendment rights does not constitute retaliation?
To my knowledge, yes.
And maybe it would be helpful to have an example of when this would come into play.
Sure. So a lot of times you may have a student on student Title IX complaint. And let's say a female student makes a complaint to the Title IX coordinator, and it hits the definition of sexual harassment under Title IX. So the Title IX coordinator opens up an investigation. And the first step in that, and we'll talk about this later, but the first step is to provide notice to the parties that there's going to be an investigation. Once the respondent, a male student in this example, receives notice of that investigation, let's say the respondent goes onto social media, goes onto Twitter, and starts making claims about his accuser, the complainant in the process. In that case, the college would have to decide whether the male student respondent's speech on Twitter was protected under the First Amendment. And if it is, then it cannot be considered retaliation. So we've talked a little bit about other misconduct that may occur, and it may not rise to the level of a Title IX violation, but keep in mind that any type of reportable misconduct should be in other college policies. So sexual exploitation is not part of the new sexual harassment definition in the Title IX regulations, but it could be covered in other college policies, along with bullying, cyberbullying, hazing, threatening or causing physical harm, other types of discrimination based on other protected classes, or sex-based discrimination that doesn't rise to the level of sexual harassment under Title IX, including intimidation.
So this brings up, I think, a very interesting scenario, Ashley. What happens if a student raises a complaint of sexual harassment and sexual discrimination, but also raises different complaints, such as racial discrimination in addition to the sexual harassment? How can colleges best meet their requirements, compliance requirements under Title IX, but be able to effectively investigate and handle claims other than just the sexual harassment claims?
So that will happen pretty often. And the first thing that you always want to do is go to your policy and read what your policy says to do. Because if it's a well-written policy, it provides a very good outline of what the steps are and what you can and cannot do. Your policy may say Title IX coordinator has authority to include other types of allegations within a Title IX complaint, even if they aren't sexual harassment. So if you have a complaint involving sexual harassment and hazing, you may include hazing along with your sexual harassment investigation if your policy allows you to do that. Or your policy may say, we separate out Title IX sexual harassment complaints and everything else. So if you have a complaint of sexual harassment under Title IX, we'll follow this procedure. And if you have a complaint of intimidation or bullying that doesn't fit sexual harassment, we'll follow this separate procedure.
Dean, one thing I might add on to that too, and we won't cover it here, we'll cover in other parts of the training, but the Title IX rule also has a emergency removal procedure for students, and it's applicable under the Title IX rule, but for people who are looking at whether or not a Title IX complaint has to be investigated alongside other potential policy violations, make sure to review and keep the emergency removal rule in effect as well, because you may have other policy violations and the conduct may be such that the student needs to be removed from the educational environment while the investigation is going on. But make sure that you keep that in mind, your obligations under Title IX for emergency removal, when you're also investigating other potential policy violations, which may not have that same requirement.
And I think those are all great valid points. And one thing that I really want to drive home is that under the new Title IX regulations, the respondent, the alleged aggressor in the situation, the respondent has a certain amount of due process rights. And even though the respondent's alleged conduct may have also violated other policies, that still is not going to diminish the respondent's rights under the Title IX policy as well, too. And so there are going to be times where you have to do an immediate removal because the allegation of misconduct is very severe, very harmful, or the respondent actually did harm somebody. But keep all of this in mind because it creates a lot of procedural nightmares for Title IX coordinators, student services coordinators, HR professionals, as they're trying to funnel everything, all this misconduct into one policy. And that may not necessarily be the case, but it's still, we have got to figure out the most efficient way to go about it. And that may change from situation to situation, but we always have to remember that if part of the allegation does rise, if true, rise to the new definition of sexual harassment, both the complainant and the respondent have certain due process rights under the new regulations that we are going to have to adhere to.
So what about online conduct? Because a lot of things happen online, especially during this age of remote work and remote learning. It's important to keep in mind that education, program, or activity, the definition encompasses all of a recipient's operations, which may include internet networks, digital platforms, and computer equipment owned or controlled by a recipient. So sexually harassing conduct is not contingent on the method by which the conduct is perpetrated. Chris, do you want to talk about this specific scenario?
Yeah, sure. So, I mean, just taking what Ashley just said and, taking the context of online, virtual, remote learning or participation, kind of fitting it into that program or activity definition and looking at how it plays out in real time. So in this scenario, a student uses a personal phone to perpetuate online sexual harassment during class time. So, the question is, does the college exercise substantial control over the student and the context in which the sexual harassment occurs? The key here are actually two keys, is that it's a personal phone, but it's happening during class time. So that makes it fairly simple that it's happening in class time. It's happening very easily within the definition of a program or activity of the college. So the harassment is going to be covered under the Title IX policy. The context in which the sexual harassment occurs is also the second part of that. But again, the key is it's happening during class time. If you switch the facts up a little bit, you can maybe see the difference. If one student receives a harassing text message from another student on their own personal time, on their own personal phone, over the weekend, not during class time, not as part of a student organization function, not while they're on campus doing an otherwise college function, but totally on their personal time, that's going to be a different analysis. And, the scope of what they're doing is probably going to fall outside of the Title IX policy. Now, again, and we've said it a couple times, and we'll probably say it a couple times more, depending on the nature of the conduct, that doesn't mean it might not be addressed through other policies that the college has in place for harassing statements or conduct. It would just mean that it might fall outside the scope of Title IX if you switch these facts up and it happened outside of the classroom dynamic.
I want to throw another hypothetical out there for both of you to kind of maybe give me some input, because this is this is where I think it becomes very gray. Let's assume two college students are engaged in a romantic relationship, and at some point in time, one of them takes, let's say a young lady takes nude photos of her boyfriend. Both, again, are college students. They're both adults. They have a bad breakup, and then the female student sends these photos out onto social media, let's say Snapchat or something like that. And it's grabbed by some other students. This occurs all off campus, but it's grabbed by some other students. They screen grab it. And the next thing you know, these photos are hanging up all over one of the academic buildings where the male student regularly attends classes. So just a general academic building. But so we have off-campus conduct that has kind of now moved to on-campus conduct. And so would that potentially meet the definition of an educational program or activity, even though most of it was done online and was done off campus?
I think so. I think the act of moving it on campus creates that substantial control scenario, because when things are posted on campus, there's a policy for that, and people are supposed to go through a college policy to post flyers, and so that would create the substantial control necessary for the college to exercise control over the situation.
And I think this is a good example of sort of the upfront, and we'll talk about investigations later. You know, an investigation under Title IX is triggered, after a formal complaint has been received by the Title IX coordinator. And we'll talk at great extent about what that investigation needs to cover, and where it may lead to a live hearing and a decision maker makes a decision at the end of that process. But I think this is a good example of highlighting the fact that the Title IX coordinator, observing this conduct or receiving a report about how something that was off campus has come on campus, is very fact-based. And this is something that a Title IX coordinator is going to have to analyze to determine on the front end before any investigation happens, any formal investigation happens, to decide, whether the scope of the conduct is actually covered by Title IX. And so this, I think, is a good example of, a situation where a Title IX coordinator would have to look at all that to make a sort of a threshold determination on the front end.
So who is covered under the new Title IX regulations? Student-on-student complaints are covered. Employee-on-student complaints are covered, meaning an employee makes a Title IX complaint against a student, and employee-on-employee complaints are covered. Additionally, applicants for admission and employment are covered under the new Title IX regulations, as are student organizations, and third parties participating in an education program or activity. And just to highlight, a college's obligation to respond to Title IX complaints is the same, irrespective of the sex of the parties involved.
Ashley, let me ask you something here. I know we have employee-on-employee sexual harassment mentioned here on this slide. Is this something new with the current regulations?
It's not new. It's been there, but the Department of Education has made it clear that employee-on-employee complaints are covered under Title IX, in addition to Title VII.
Wow, so I guess it's very important for not only the Title IX coordinator to understand this, but also human resources administrators, that if there is an employee-on-employee complaint that rises to the level of sexual harassment under Title IX, that there is likely going to be a new process on how to handle that complaint, investigation, and decision-making.
Exactly. So again, it doesn't matter if the persons are the same sex in a Title IX complaint. Title IX and Title VII protect all covered persons from discrimination based on sex, regardless of sex, gender identity, or sexual orientation. And claims of discrimination based on gender identity are investigated by the Office for Civil Rights.
The Department of Education spent a lot of time talking about this in its commentary to the new rules, didn't it?
I think so.
Yeah, and so I think it's always important to drive home this point that it doesn't matter what somebody, what their sexual orientation is, that even a straight male or straight man may sexually harass a gay or bisexual man, and vice versa too with females, and it certainly does not apply to any particular gender identity either. And so, Ashley, is it safe to kind of assume that it's never an appropriate defense to a Title IX sexual harassment complaint where the respondent says, well, I'm not gay, therefore I couldn't sexually harass this other man?
That's correct. So do disabled students need special consideration? Yes. The information made to the student body and employees should be accessible to students with disabilities and employees with disabilities. Your school may need to consider counseling or psychological services to assist a student in understanding their rights in the event of an investigation. And during the grievance process, the Title IX coordinator may need to provide reasonable accommodations to one or both of the parties if it involves a student or an employee with a disability.
All right, folks, this is going to end the first section of the first video. We'll cover section 2, Title IX personnel, and some other compliance issues in the next video. And just want to make sure that you kind of understand that we will have this series of 4 videos that will put together the entire training seminar. Some videos will be specifically focused for certain individuals, such as investigators or decision makers, but certainly we do suggest that Title IX personnel or the Title IX coordinator and anybody working in the Title IX office or with the Title IX coordinator is able to watch all these videos. This particular section, this very first video, could also be used, or portions of it could be used, to train other staff members on what a Title IX sexual harassment complaint is and who to report that to. So thank you for listening, and we'll be back with the next video in the series.